Hello, my name's Mon and this is Rebecca. We're part of the Employment and Immigration team, and this is quite a niche webinar on the question of what happens when sponsored workers are made redundant. We will be sharing a copy of these slides at the end, but our agenda is we want to remind you of what the sponsored worker categories are, some points to note, and when you're dealing with a redundancy, particularly what is a redundancy and your legal obligations to a sponsored worker, some practical considerations, both for the sponsor and their family, but also this idea of consistency when you are making anybody redundant within your organisation. There are obviously reporting duties, right to work checks and visa cancellations that we will also discuss. So Rebecca's first going to remind you of the categories that fall within the visa requirements.
Hi, so I'm going to just run through the most common sponsored categories. There are other categories that also qualify for sponsorship, but these two are the most prevalent. So firstly, there is the skilled worker route, which has replaced the Tier 2 general route. This route provides a route to settlement after 5 years in the UK with either the skilled worker leave or the Tier 2 general leave. Secondly, there is the global business mobility senior or specialist worker, a very long name, which has replaced the ICT or the Tier 2 ICT routes. This route is for existing employees of linked organisations overseas who are coming to the UK to do a job for the employer in the UK. This route does not provide a route to settlement, but you can switch in country to the skilled worker route. But importantly, you cannot combine skilled worker leave and global business mobility leave to reach that 5-year qualifying period. So just a few points to note before we go into the detail. A sponsored worker's right to live and work in the UK is directly linked to their visa. So what that means is that they're limited to working for their sponsor in the role stated on their certificate of sponsorship, which is called a COS. There are exceptions to this. There is the exception where they can work for up to 20 hours a week in a job at the same level with the same occupation code or in a shortage occupation role. If a sponsored worker's visa is cancelled, they lose their right to work in the UK unless they qualify for a different type of visa which allows work in the UK. And lastly, sponsored workers are normally employees of the sponsoring organisation, but this is not always the case. There are self-employed partners in a limited liability partnership which can also be sponsored. So just a few more points to note. There are immigration categories which give a general right to work as opposed to working only for your sponsor. These include the graduate route, which is relatively new, and also those with status under the EU settlement scheme, the EUSS, either settled or pre-settled, those with indefinite leave to remain or indefinite leave to enter, which gives a right to work indefinitely in the UK. There are partners of sponsored workers who have a full right to work. There are UK ancestry, youth mobility, high potential individual, and the new India Young Professional Scheme route.
Let's look at when a redundancy situation is triggered. The legal definition of redundancy is there is a reduction for the need of somebody to do that particular work in a particular location. It could be a restructure, but generally you're seeing a diminution of the work that's required. If it could be part of the business is moving abroad, but be wary that there's not a transfer of an undertaking happening if the role is moving overseas. And it may be that you have a sponsorship licence and intercompany transfers, so individuals can be moved to different locations relatively easily. When this happens, it could be that your sponsored workers will be part of the workforce that either needs to be pulled because there's going to be less of them, or their unique roles are no longer required. The general principle is that you must treat those that are on visas, or sponsored workers, the same as those that are not sponsored. This is the idea of equality and fairness. Generally, to have redundancy terms, employees have to have 2 years service. There is always a process of consultation. It may be just individual consultation, but it also must be maybe collective consultation. And this is where you have 20 or more workers that are being made redundant, and that includes voluntary redundancy within a 90-day period. At the moment, we're not seeing mass redundancies, but what we are seeing is smaller restructures and the 20 workers being caught when people add up the number of employees that they've not needed in that 90-day period. There is an obligation in a redundancy to find a suitable alternative role, and that's one of the questions you ask. They don't get any preferential treatment. However, if the role is in a different occupation code, that will mean you'll need to get a new COS and a new visa application required. You cannot just slot people in. If they're offered a role in the same occupation code, we just have to report the details within the 10 working days of the change required. As part of the general redundancy consultation and obligations, there are some specific ones that relate to sponsored workers. So you do need to confirm in writing their termination date. Generally, that's not a problem because you would be doing that in any event. There's no extra legal protections that need to be given to a sponsored worker, even though their employment is wholly related to that employment. Redundancies are hard for individuals, and particularly we are seeing that they're creating a high level of anxiety at the moment. And that is just generally, if your right to actually live is also dependent on your visa, it does create more anxiety, and there is an obligation on HR departments to foresee that and see what measures they can do to alleviate the stress that is caused by that process. So, some of the practical considerations are that you may say that we could let them work out their notice period, because that extends their right to work in the UK, and more importantly, it allows them to perhaps find alternative employment with another organisation that has a sponsorship licence. It depends on your contractual terms, so the ability to make them work their notice or put them on garden leave or make a payment in lieu is solely dependent on the contractual terms, and most employers have a variety of all three. What you want to be able to do is perhaps a combination that suits the business, but there needs to be, again, this equality of terms. So if somebody who's on a visa is allowed to work out their notice, others you might want to consider for other reasons to be allowed to be put on garden leave. That does have normally financial consequences. Rebecca and I are really lucky. We were privileged to work with excellent clients. I don't know why Rebecca is laughing there, but we have. And the reality is we learn more from our clients than perhaps the other way around. Some of the best clients really look at when they are offboarding employees, that they do that with a high level of care. So I have seen brilliant booklets where actually organisations are signposting actual vacancies with competitors to help colleagues find a job elsewhere if they wish to remain in the UK. So just be wary that a sponsored worker is likely to ask for these things and the consideration of that. I suppose I should also tag here that the way you treat a sponsored worker may give rise to claims of discrimination, because sponsored workers generally, by their very nature, do not come from the UK, and they may be saying that this was a detrimental application of your redundancy process.
So, following on, just a few more points to note regarding the end of sponsorship when a sponsored worker is either made redundant or their employment is terminated. As a sponsor, you must report the end of sponsorship no later than 10 working days from the last day of employment. And I've listed there what steps you need to follow on the SMS to do this. And in this report, it is mandatory to include the termination date and the worker's last known address. It's optional to include their email address, but this is highly recommended as the Home Office corresponds primarily via email, and you want to make sure that that worker receives the all-important curtailment notice, which I will go into later on.
Rebecca, there are two issues here. One is, well, they both relate to reputation. So when an employer sponsors a worker, they are in effect making a statement that this employee has guaranteed employment, and I don't mean that in a contractual sense, but for a period of time. And that creates reputational risk when an employer can't deliver, although circumstances of course do change. But do you think if an employer is making redundancies, when it comes to the annual allocation of COSs and when they're asking for visas, that the UKVI may question an employer in the future about their visa requirements if they are terminating visas for reasons related to redundancy?
I think that if there is a large amount of redundancy in a cause allocation year, because you do need to say the reason for the end of sponsorship, and redundancy is listed as one of them. I think it definitely could impact the Home Office's decision in deciding to allocate the same number of causes in the next allocation year. The process has changed recently where it's becoming automated. So what happens now is you will be allocated a certain number of causes depending on how many you assigned in the previous year. That being said, if there are a certain number of redundancies, the Home Office may write to the sponsor to find out if the same number of causes are actually required in the next year. It's hard to say.
I suppose it might also trigger an audit.
It
perhaps.
may. Okay, so just going into some practical considerations from the point of view of the sponsored worker. When made redundant, there may be a settlement agreement, and it may be possible to ask for or negotiate with the employer certain provisions to be included, which would be helpful for their immigration status. They could ask for the report of the termination date to be made on the last working day, so the 10th working day following the termination date. As Monica said, they could request to work out their notice period or take garden leave to delay that termination date. If they have found a new sponsor, they could ask for this termination date to be brought forward instead of having to work out that notice period. They could also request that they don't have to repay the visa fees associated with their visa application. And lastly, they could request for any legal fees relating to the review of their settlement agreement to be paid for, given the circumstances. Just to go a little bit further into the repayment of visa fees. So it is becoming quite common now for there to be clawback clauses in sponsored workers' employment contracts, which state that they will have to pay back certain fees if they leave their sponsored employment within a certain amount of time. These fees can only include, number one, any legal costs paid by the sponsor to prepare the cause and visa application, the Home Office visa application fees, and the immigration health surcharge, which covers the cost of medical treatment whilst in the UK. It's important that sponsors know that you can't require these workers to pay the sponsorship fees, which they have outlaid. So that includes the cause assignment fee and the immigration skills charge.
Again, I think there's got to be parity, because most contracts say on a redundancy that fees for training broadly and these visa fees, it seems harsh to seek for a repayment, even if you've got a contractual type, when you have elected to make somebody redundant. It's almost like a no-fault termination.
So another important consideration is right to work. So as I said, the sponsored worker's right to work is wholly attached to their visa. So following that termination date, they no longer have the right to work in the UK. And this is even the case if their visa has not yet expired. And sometimes there can be months, even years left on a visa. But once that termination date has passed, you cannot work in the UK. And this includes self-employed work, and it also includes temporary unpaid work whilst you're obtaining a new visa. Also, the supplementary employment rights, so those 20 hours per week in certain roles, also end on the termination date. So once a sponsored worker's visa has been notified on the SMS that its the sponsorship has ended, what will happen is the Home Office will receive this report on the SMS, and then they will prepare to send out what is now called a curtailment notice, which notifies the worker that their visa has been cancelled and how long they have to either apply for a new visa or leave the UK. The curtailment notice period is not a set amount of time. Normally it's 60 calendar days, but there are cases where workers are pregnant or in ill health, and this may be considered, and then the notice period would be extended. But normally you're looking at 60 calendar days. So there will be this waiting period between the termination date and receiving the curtailment notice and the end of the 60-day notice. And it's important to note that during this time, the worker has the right to live in the UK but not work in the UK. So just going on to the curtailment notice period. This period is crucial in allowing the worker to find new sponsorship or apply for a visa which allows them to work. It's possible for these sponsored workers who have been made redundant or have their employment has been terminated. They can look on the register of licensed sponsors on the government website, which they can use to check whether the companies they're applying to already have a sponsor license. Before the end of the notice period, in order to continue that lawful leave in the UK, the worker must submit a valid application for a new visa. This doesn't mean that before the end of the notice period, the visa has to be granted. It only means that they have to submit a valid application. So what that means is it's submitted online, the visa fee has been paid, they've received confirmation that has been submitted, and once that valid application is put in, their right to work does not resume, but it safeguards their permission to stay in the UK until their visa is granted. So, if the worker is able to secure employment with a different sponsor, they will need to obtain a new cause from that sponsor, and they'll need to submit a new visa application, which is called a change of employment visa application. They cannot start working for that new sponsor until they receive their new visa and the right to work check is carried out properly. This will be faster if the worker has used the ID check app provided by the Home Office. But if the worker has gone via the traditional route, which is the biometric appointment, they will need to wait for their new BRP card, which sometimes can cause delays when there's issues with the post. But it is very important to note that you cannot start working for your new sponsor until that right to work check has been carried out. Some workers will worry that there's a break in their employment when they've had to leave one sponsor and go to another. But this break in employment should not impact their eligibility to settle in the UK, so long as they submitted that new visa application before the end of their curtailment notice period. So, moving on from when a worker has found a new job with a new sponsor. It may be they've found a new job with an employer who doesn't hold a sponsor license. And this, of course, will create some issues. So firstly, the new employer will need to apply for a sponsor license. And this license must be obtained before they can get that cause and before they can submit their new visa application. You have to take into consideration the preparation time for license application. There's many documents that need to be compiled. And once submitted, there is that 8-week standard processing time. And there is a priority service, which the sponsor can pay for, but it's a first come, first serve service, which is capped at 30 per day. And we are seeing a huge number of license applications currently, around 1,000 per week. So this is something to consider. It's always important to, when you're looking at jobs as a worker, it will probably be easier if the organization you're looking to apply to already has a sponsor license. So travel. Once a sponsored worker has received that curtailment notice period, and even when the employment termination date has passed, it is advisable to not travel outside the UK. There are many workers who would love to travel for many reasons, but we always advise to just try to postpone that travel until they've received their new visa. It's hard to say whether the immigration officer they're dealing with at the time at the airport will be happy to let them back in, or whether there will be issues created and they'd be refused entry. So it's always advisable to postpone travel unless absolutely necessary. But if you do travel without receiving your new visa, it's important that you do not enter via the passport e-gates when you come back in, even if you are allowed to based on your nationality, because if you do, you'll be looked at as entering as a visitor, which will prevent you from being able to obtain any new visas once you're back in the UK. So, of course, these sponsored workers commonly have family members who are dependent on their visa. So these dependents, they have the full right to live, work and study in the UK as dependents of the main sponsored worker. What is different is that following the termination of their sponsored family member, they will receive curtailment notices, but their right to work does not immediately end on their family member's termination date. Their right to work continues until the end of the curtailment notice period or their visa expiry date, whichever comes first. It may be in some situations that a dependent spouse or unmarried partner is working for an organization who holds a sponsor license, and it may be that they are able to obtain sponsorship from their organization, and the situation kind of flips where their main sponsored family member, who is either made redundant or their employment ends, becomes their dependent. And what that means is that they would have to submit new visa applications, the whole family, before the end of the curtailment notice. Well, thank you for attending our webinar, and if you have any questions, we'd be happy to answer them by email.
Thank you very much. Bye-bye.